Energy Program and motion to deviate from Utah Admin Code R746-314-402-4. It's Commission Docket number 24-035-55. My name is Michael Hammer, and I'm the Commission's designated presiding officer. Let's take appearances, please, beginning with Rocky Mountain Power.
Yes, Catherine Smith on behalf of Rocky Mountain Power.
And for the Division of Public Utilities.
Patrick Riccio, Assistant Attorney General, representing the DPU.
And for the Office of Consumer Services.
Robert Morris, Assistant Attorney General, representing the Office of Consumer Services. With me is Bella Vastag, a utility analyst from the office.
And does the Community Renewable Energy Agency, which I'll just refer to as the agency, have counsel on the line?
Yes, Phil Russell on behalf of the agency. And I'll note there are a number of representatives from the agency also with us. What I can see is Christopher Thomas, Dan Dugan, Luke Carton, and I think Roger Armstrong. I saw, yeah.
Okay, I don't believe, were there any other interveners? I don't think there were. All right. So Ms. Hayes, I take it you're here to spectate?
Yes, Sophie Hayes on behalf of Western Resource Advocates. We submitted public comments in this docket and just wanted to clarify that we don't intend to call a witness today.
Great, thank you. All right, well, is there anything we need to address before Rocky Mountain Power calls its first witness? All right, Ms. Smith, please call your first witness.
Thank you. Rocky Mountain Power would like to call Craig Eller as company witness.
Mr. Eller, do you swear to tell the truth?
I do.
Go ahead, Ms. Smith.
Mr. Eller, please state and spell your name for the record.
My name is Craig Eller, C-R-A-I-G-E-L-L-E-R.
By whom are you employed and what is your business address?
I'm employed by Pacificorp. Our address is 1407 West North Temple, Suite 310, Salt Lake City, Utah.
And what is your role with the company?
I'm the Senior Vice President of Resource Strategy and Development.
And in your position, have you had the opportunity to review the application and relevant comments?
Yes.
Can you please provide a summary of your position?
Yes. Good morning, Mr. Hammer. I present today for Commission approval of a solicitation process and motion for deviation from Utah Administrative Code R746-134-402, Part 4. On November 19th, 2024, the company filed its application seeking approval to run a solicitation process for a community renewable energy program pursuant to the Community Renewable Energy Act, which I'll refer to as ACT, signed into law March 29th, 2019. The ACT enables the creation of a community renewable energy program, which is to be designed in coordination between the company and the participating communities represented by the agency, to enable participating Rocky Mountain Power customers within the Utah renewable communities to receive 100% of their annual net energy usage from non-emitting sources. This application seeks approval of the 2025 Utah Renewable Communities Request for Proposal for Clean Energy Resources, which I'll refer to as the URC RFP. The URC RFP will be administered by the agency on behalf of customers that participate in the program. The company and the agency intend to file this solicitation application now to seek approval of the URC RFP as part of the program and anticipates that it will provide guidance on potential costs for program resources, which will help determine the proposed program rate. As part of its application, the company filed a motion for deviation from Utah Code R746-314-402, Part 4, to streamline the solicitation process. Under the current set of solicitation rules, the company would need to adhere to one set of solicitation rules for a solar resource and another set of solicitation rules for a non-solar renewable resource. Because the company and communities are open to soliciting and acquiring either solar or non-solar renewable resources, the company requested to deviate from R 746-314-402 Part 4 and instead proposed a single set of rules that combined both of these sets of rules. The combined proposed rules mirror both the solar and non-solar solicitation rules and provide the company with the ability to streamline the solicitation process and avoid undue hardship by running a single solicitation. In its comments, the DPU did not oppose the company's RFP solicitation process or the proposed single set of rules. The DPU did request further discussion of transmission considerations and prevention of cost shifting to non-participating customers. The company understands these concerns, but encourages parties to explore these issues further in docket number 25-035-06, which considers program implementation. In its comments, the OCS recommends the Commission wait to approve the solicitation until after program implementation has been vetted and approved in docket number 25-035-06. The company understands why the OCS would recommend this. However, the company believes the Commission can approve the solicitation prior to program implementation because the results of the solicitation will help determine aspects of the program itself, including program rate design. Therefore, the company respectfully requests the Commission to approve the solicitation now prior to program implementation and prior to approval of the program resources acquisition and construction. The Community Renewable Energy Agency, the Utah Clean Energy, Boat Solar, and Western Resource Advocates also filed comments and support approval of the program. In summary, the company respectfully requests the Commission issue an order approving the company's application for solicitation for the Community Renewable Energy Program. Thank you for your time.
Thank you. And I just have one quick clarifying question. Mr. Eller, we are requesting to deviate from R 746-314-402 Part 4, correct?
Correct.
Okay, perfect. Thank you. And that's all I have for company witness. He is available for, I'm sorry, I'm going to back up a second. The company would like to move to admit the application and correlating exhibit.
They're both admitted.
Thank you. Now the witness is available for cross-examination and questions from the hearing officer.
We'll go to Mr. Grecu.
I have no questions. Thank you.
Mr. Moore? I believe you're on mute, Mr. Moore.
My apologies. No questions. Thank you.
Mr. Russell?
No questions. Thank you.
All right. Any other witnesses, Ms. Smith?
No other witnesses. Thank you.
All right. We'll go to the Division of Public Utilities and ask Mr. Grecu to call his witness.
Thank you. The division calls Mr. Robert Davis.
Mr. Davis, do you swear to tell the truth?
I do.
Mr. Davis, could you please state and spell your name for the record?
Yes, it's Robert Davis, ROBERT DAVIS.
And by whom are you employed and what is your position?
I'm employed by the Utah Division of Public Utilities as a utility technical consultant.
And what is your business address?
It is 160 East, 300 South, Salt Lake City, Utah.
And have you participated in this docket on behalf of the division?
I have.
Could you briefly describe your involvement in this docket?
I I am the team lead on this project, and so I've reviewed everyone's all of the parties' comments and exhibits.
And did you prepare and cause to be filed the division's comments filed on January 28th, 2025, and reply comments filed on February 13th, 2025?
Yes,
And do you have any changes or corrections to those filings?
I do not.
Did you adopt the contents of those filings as part of your testimony today?
Yes,
At this point, I'd like to move to admit the division's comments and reply comments filed in this docket.
They're admitted.
Thank you. Mr. Davis, based on your review, would approval of the application be in the public interest?
yes,
And do you have a summary to share today?
I do.
Please proceed.
Good morning, Mr. Hammer. The division has reviewed the application, supporting documentation, responses to data requests, and the parties' comments in this docket, as well as having discussions with various parties. The division is not opposed to the approval of the solicitation process for the Community Renewable Energy Program and motion to deviate from Utah Administrative Code R746-314-402, Part 4, as proposed by Rocky Mountain Power and the agency. The division has the responsibility to evaluate programs such as this one to ensure the program is prudent and in the public interest. The division is aware of the complexities of designing the community renewable program without knowing the generation resource availability and pricing, and also how lacking an approved program design may affect getting generation resources. The division's concerns lie in the avoidance of cost shifting to non-participants, the transparency of the program to customers within the communities, and customers' ability to opt out should they choose not to participate in the program. The division raised several concerns and conditions in its comments regarding pricing, transmission availability, cost shifting, resource ownership, and the actual need for additional generation resources. At the time of RMP solicitation filing, the division anticipated that the program application would eventually be filed as part of docket number 24-035-55, and therefore raised initial concerns and conditions in its comments and reply comments. Since that time, RMP has responded to the division's data requests and has had discussions with the agency. The division anticipates that most, if not all of its concerns and conditions will be addressed in the forthcoming program filing in docket number 25-035-06. In conclusion, the division is aware of the complexities and difficulties in the timing of the generation solicitation process and program development when neither are known with certainty. Based on the division's review of the information provided in this docket, the division concludes that approval of the solicitation process and changes to the solicitation rules as requested are in the public interest and recommends the commission approve the solicitation process. A motion to deviate from Utah Administrative Code R746-314-402, Part 4, as proposed by Rocky Mountain Power and the agency. This concludes my summary. Thank you.
The witness is now available for cross-examination and questions from the hearing officer.
Ms. Smith,
No questions.
Mr. Grieco. I'm sorry, Mr. Moore,
No questions, thank you.
Mr. Russell.
No questions. Thank you.
All right, I have a few, but I think they'll be better answered by counsel, and we'll just address that after all the witnesses have testified. So I don't have anything for you, Mr. Davis.
Thank you.
No other witnesses, Mr. Grieco?
Nothing further from the division.
Mr. Moore, would you like to call your witness?
The Office of Consumer Services calls Bella Vastag and asks that he be sworn.
Mr. Vastag, do you swear to tell the truth?
Yes, I do.
Mr. Vastag, could you please state and spell your name for the record?
My name is Bela Vastag, BELA-VASTAG.
How are you employed and what is your business address?
I am an utility analyst employed by the Office of Consumer Services, and our business address is 160 East, 300 South, Salt Lake City, Utah.
In your capacity as a utility analyst, did you have the occasion to review the application and the comments that have been filed in this case?
Yes,
Did you prepare and cause to be filed the Office of Consumer Services comments in this docket on January 28, 2024?
yes,
Do you have any changes you'd like to make to these comments at this time?
no, I have no changes.
Do you adopt those comments as your testimony today?
Yes,
At this point, I move submission for the Office of Services January 28, 2024 comments.
They're admitted.
Have you prepared a summary of the Office of Consumer Services position in this case?
yes, I have.
Please proceed.
Good morning, Mr. Hammer and everyone else here this morning. In our comments filed January 28th, 2025, the Office of Consumer Services, or OCS, raised some concerns about whether the Community Renewable Energy Agency will have sufficient expertise to conduct an RFP process for new electric generating resources and to evaluate the bids that are submitted to that RFP. The application in this docket states that Rocky Mountain Power has no role in administering the RFP or selecting winning project bids. However, on February 13th, 2025, the agency filed reply comments demonstrating the expertise of the agency and its consultant have in administering an RFP, and they clarified that the modeling that Rocky Mountain Power will provide to assist the agency in its evaluation of the RFP bids. In our comments, the OCS also advised that no resources resulting from the proposed RFP process in this docket should be approved until after the Community Renewable Energy Program design and details have been thoroughly vetted and approved by the PSC in docket number 2503506. In their reply comments, both the agency and Rocky Mountain Power agreed with this recommendation. In this application, Rocky Mountain Power has also requested to deviate from Utah Administrative Code Rule R746-314-402, Section 4, requiring separate RFPs for solar and non-solar resources because federal tax regulations have changed since these rules were created. RMP also proposed new language for these rules, primarily to incorporate the updated status of solar resources. Both of these proposals regarding the RFP rules appear reasonable to the OCS, and we do not oppose them. It is the OCS's view that the RFP process and rule changes proposed in this docket are reasonable so long as any risks associated with resources procured from this RFP process remain solely with the Community Renewable Energy Program and its participating customers. As I stated earlier, these issues will be addressed in a separate docket when the proposed program design is reviewed by parties. Therefore, the OCS recommends that the PSC approve Rocky Mountain Power's request in this docket. And finally, as I discussed earlier in my statement, I'd like to clarify what Mr. Eller said in his summary, that the OCS does not oppose the approval of the RFP in this docket, but we stated that any resources chosen when the RFP is conducted should not be approved until after the program design is vetted and approved in docket number 2503506. And that concludes my statement.
Mr. Vastag is now available for cross and questions from the hearing officer.
Ms. Smith,
No questions.
Mr. Griecu.
I don't have any questions.
Mr. Russell.
No questions.
Mr. Vostok, just to be clear, does the OCS still contend that the PSC should not issue an order approving the solicitation until the other docket approving the program is resolved? Or is it the office's view that we can approve the solicitation, just the solicitation process at this juncture?
That's correct. We recommend approval of the solicitation process, but of course, any resource that was chosen when this process is conducted should not be approved until after the design of the program is established and approved.
All right, thank you. Mr. Moore, any other witnesses?
No other witnesses, thank you.
Mr. Russell, would you like to call your witness?
Yes, the agency calls Christopher Thomas.
Mr. Thomas, do you swear to tell the truth?
Yes.
Good morning. Could you state and spell your name for the record, please?
Yes. Good morning. My name is Christopher Thomas, spelled CHRISTOPHER. Thomas, THOMAS.
And can you tell us who you work for and in what capacity?
Yes, I work for Salt Lake City Corporation in the Sustainability Department, and my title is Senior Energy and Climate Program Manager.
On whose behalf do you appear here today?
On behalf of the agency.
And do you appear here today on behalf of the agency to support the company's application for approval of the solicitation?
Yes, I do.
Did the agency submit initial comments and reply comments in this proceeding?
Yes, it did.
Have you reviewed those comments filed by the agency?
Yes, I have.
And do you adopt those comments as your testimony in this proceeding?
Yes, I do.
And at this stage, I'll move for the admission of the agency's comments as Mr. Thomas's testimony.
They're admitted.
Mr. Thomas, have you prepared a summary that you wish to share with us today in support of the application?
Yes, I have.
Please proceed.
Great. So this morning, I want to address 4 topics in my summary comments. First is why the agency supports changing the solicitation rules. Second, why the agency wants to pursue a solicitation now instead of after program approval. Third, a brief description of the proposed solicitation the agency wishes to run. And fourth, and finally, how many of the questions raised by the division and the office will be addressed in the program application docket. So first, the agency supports changing the solicitation rules because the current solicitation rules treat solar and non-solar resources differently. This different treatment arose from the fact that solar and non-solar resources historically were eligible for different kinds of clean energy tax credits. However, federal tax policy has changed, and solar and non-solar resources can now make use of the same types of tax credits. For this reason, the agency believes it is simpler for both the agency and bidders to use a single solicitation procedure that applies to both solar and non-solar resources. The agency worked with Rocky Mountain Power to develop the new procedure and supports Rocky Mountain Power's motion to deviate to use the new procedure. The division raised a concern about one aspect of the proposed procedure, that it would allow the agency to acquire a program resource through a company-run all-customer resource solicitation. The agency notes that the current solar solicitation rules expressly contemplate that a large customer may select a resource from a company-run all-customer solicitation. Additionally, the company's 2022 all-source RFP also provided that large customers could select resources, but only after the company's selections for all customers and to address any state-specific requirements. The proposed procedure would simply formalize this opportunity for future all-customer solicitations run by the company. Because the proposed solicitation would be conducted by the agency at the agency's expense, it would not be impacted by a commission order declining to approve that part of the proposed solicitation procedure. However, the agency would like to have the ability to acquire from a future all-customer solicitation run by the company, subject to the...
Mr. Thomas?
Yes.
You broke up just a little bit. Could you go back a sentence?
Oh, absolutely. Thank you. Because the proposed solicitation would be conducted by the agency at the agency's expense, It would not be impacted by a commission order declining to approve that part of the proposed solicitation procedure. However, the agency would like to have the ability to acquire program resources from a future all-customer solicitation run by the company, subject to the limitations as described in the proposed solicitation procedure. Second, the agency wants the ability to run a solicitation now so that the initial program rate adopted in a second proceeding, docket number 25-035-06, can better reflect the quantifiable projected costs and benefits of program resources. The primary driver of both program costs and benefits is the resources acquired by Rocky Mountain Power to serve the program. For that reason, it is important to test the market as soon as possible for resource bids and to have Rocky Mountain Power analyze those bids to assess system benefits. This will greatly assist the parties in assessing the rates that can be expected to apply to program participants. Third, let me briefly describe the agency's proposed solicitation. The agency wishes to solicit clean energy resources that can achieve commercial operation no later than 2029 from projects that have already advanced in the PacifiCorp transmission interconnection queues and that can be constructed by companies who have already delivered similar projects. We plan to have bids submitted to a third party, Energy Strategies, who will aggregate, anonymize, and screen the bids. Next, bids will be scored by the consultant for price and non-price characteristics. And finally, up to 6 bids will be analyzed by Rocky Mountain Power for projected system benefits and emission reductions, and evaluated by the agency's consultant for commercial online readiness. The final evaluation is driven primarily by the price score, which makes up 70 of the 100 possible points. Remaining bids will be ranked and selected for contract negotiation. This proposed solicitation will be undertaken by the agency and at the agency's cost. We acknowledge that by running the solicitation before the program application is approved, the agency is undertaking a risk that program resources may be selected but never approved by the commission. However, we think this risk is outweighed by the need to get the resource pricing data that we need to set the rates for program participation. Fourth, I want to address a concern raised by both the office and the division, which is that program costs and benefits cannot be shifted to non-participating customers. It agrees and notes that the program can't be approved unless the commission is satisfied that the costs and benefits of the program will be captured by the program rate. The agency and company believe this issue will be fully addressed in the program application docket, and the agency believes the program can be designed to prevent shifting projected program costs and benefits from participants to non-participants. The commission will also have a chance to approve or deny any signed power purchase agreements resulting from the agency's proposed solicitation, and any such signed contract would not become effective unless and until the program itself is approved. We believe this regulatory sequence adequately protects customers from any cost shifting while allowing program development to proceed. And that concludes my comments.
You're muted, Mr. Russell.
Thanks. Sorry. Thank you, Mr. Thomas. Mr. Thomas is available for cross-examination and questions from the hearing officer.
Ms. Smith,
No questions.
Mr. Griecu,
No questions.
Mr. Moore,
No questions, thank you.
and I have none. Thank you, Mr. Thomas.
Thank you.
Any other witnesses, Mr. Russell?
No other witnesses. I do have one minor housekeeping note. I'll note that the division, the office, and the agency have each moved for the admission of their comments as testimony. I didn't hear the company do that, but I want to invite them to do that if they'd like to.
Thank you. The company would like to move for admission of its comments at this time.
They're admitted. We did admit the application, correct?
We did.
Okay.
Takes a village.
All right. Before we adjourn, I just was hoping for some clarification, and I suppose I'll throw this to Ms. Smith first, and then we can go see what everybody else thinks. But as I see it on the issue of the waiver, it's sort of two issues. We have whether to waive the rule as regards subpart 4 and allow the non-solar and solar resources to be included in the same request for proposals. And then there's this proposed rule that's attached to the application and whether or not that ought to be adopted. So I suppose my first question is, can the commission give the company what it's asking for simply by granting the waiver and without adopting the rule at this juncture?
I think the company and the agency imagined substituting the proposed rules in addition to the deviation of 314.402, because we drafted those proposed rules to incorporate both sets, that being both sets non-solar and solar. Unfortunately, I don't have the language up in front of me right now, but I think it would still be helpful to incorporate the proposed sets of rules for the solicitation, just for clarity's sake in the record.
So it's essentially an order that states we grant the waiver, and with respect to this specific RFP, the rule proposed here shall govern, but you're not suggesting that the admin code actually be amended.
Correct. That would be the company's preference.
And let me just ask then all council whether they would object to that relief. Going first to Mr. Griecu.
That's how the division understood it to work, and there's no objection.
Okay. Mr. Moore?
No objection.
Mr. Russell?
No objection to that. That is what we had intended with the request.
All right. Well, thank you for the clarification. Appreciate it.